Hello, everybody. This is Dimitri Dovas speaking. We are going to have a discussion about intellectual property issues for startups and small companies. If you have any questions, you can buzz in. We have a pretty informal format here, so don't be shy. If I don't get to you immediately, we can try to get to you after the substantive portion of the presentation, which I'm trying to keep around a half an hour. So let's just talk briefly about some of the initial considerations that a lot of startups will come to me with. One of the big things that people have when they have a startup is they want to talk about their ideas, and they want to talk about how important their ideas are, and we want to talk about the ways that we can try to protect those ideas. So what comes to most people's minds are patents, trademarks, copyrights, trade secrets. So let's start with patents. A patent protects is a tangible asset for that can be used to license or to sell. The holder of a patent is enabled to prevent someone else from using, manufacturing, distributing goods or services, whether it be software, whether it be some kind of tangible good. But what it doesn't do is it doesn't actually give you the right to make that product. So even if you have a patent, doesn't necessarily mean that you'll be able to sell that product, because someone else might have a patent on another aspect of that particular product or service that precludes you from being able to do so. So some of the drawbacks of a patent are, it's expensive. You have the time it takes to prosecute the patent. You have the time it takes to the cost it takes to prosecute that patent. You have the maintenance cost, and if you want to enforce that patent against someone, well, you got to pay money for that too. The other issue is that when you're filing for a patent, that subject matter that you're filing a patent for becomes public in most cases. So if it's something you wanted to keep secret, a patent might not be the right tool for that. Now, a lot of times people will come to me with something they want to patent, and they'll say, we've been selling this product for a couple of years, and now we're ready to patent it, or we gave a presentation about this particular product at a trade show last year, and they're prevented from filing that patent because when you take certain actions, be it public disclosure, use, offer for sale, that can prevent you from being allowed to actually file a patent. Now there's a 12-month grace period after certain disclosures or offers for sale in the United States, but many other countries where you might look for patent protection don't offer that kind of grace period. So if you are thinking about patent protection for something, you have to talk to someone as soon as possible, and preferably before making any types of disclosures or offers for sale, so that you're not precluded from filing for a patent. Now, I don't want to get too detailed into the foreign filing rules, but there's no such thing as an international patent. So if you are considering patents in other jurisdictions outside of the United States, you're going to need to file in those other countries or jurisdictions individually. They do have what's called a international patent application, or a PCT application, and functionally what that does is it gives you some extra time to file in those other foreign jurisdictions. For example, if you file a PCT application Today, you have up to 30 months or 31 months, depending on the jurisdiction, to file in another country or jurisdiction, 30 months from your original filing date. Let's say in the United States, you file a patent application today, and you file a PCT application, in 6 months from now, you get 30 months or so from the original U.S. application to file in particular foreign jurisdictions. Now, there are exceptions and different rules in particular jurisdictions, but generally speaking, PCT application can buy you some time to file in foreign jurisdictions. Of course, the other consideration that people will often come to me with is their trademark interests, and I think for the cost, filing a trademark application to protect someone's brand, their company name is very advisable. The cost is relatively low. The potential protection for that trademark registration affords is relatively strong, and it's inexpensive compared to a patent, for example. The costs of not having filed or registered for a trademark can be very high, especially if you've already put a lot of money into your brand, and you find out that maybe another company already has particular rights in that trademark and is looking to prevent you from using that trademark. And that often happens at a point where your company starts to gain traction and becomes a little bit more well known. So I definitely recommend taking the time to talk with someone about federal trademark protection. Another thing that comes up is searches, whether it be for use of a particular technology or use of a particular trademark. Search to determine if someone else is already using a particular mark, see if someone else is already has patent rights in a particular technology. These are things that are relatively low cost compared with actually having to stop using a particular technology or having to stop using a particular brand, a particular trademark, because someone else, once you start to gain traction or once you become noticed, considers that your mark or your technology is infringing their intellectual property rights. So a big part of what I do as an attorney is looking into seeing whether or not your mark, your trademark, or your technology might infringe someone else's intellectual property rights. At this time, I just want to open up to see if anyone might have any questions or thoughts before we move on. Well, in any case, we can get to any questions at the end of the presentation. Oh, another consideration for people who are doing, let's say, software as a service in particular, is figuring out who is owning the data that you are mining or you are using in the processes for your software. For example, in the IoT sphere, you may be collecting data from machines, from let's say if it's for consumers appliances, and you may be using that data in figuring out, how your machine can work better, in training your artificial intelligence systems. So a big part of putting together the terms of use or the terms of service for these software or cloud-based systems is to make it clear to your users who's actually owning this data. So for IoT machinery in particular, you should your terms of service. It would be good to let your users know in the terms of service that that you own the data, preferably in de-identified form, and you're able to use that data in a limited manner, for example, to train your artificial intelligence systems for better functionality of your service. Another thing to know about for software companies is whether or not you're going to be using open source software. And if you are using open source software, know what type of open source software is. Certain open source software is considered to be restrictive and requires making the source code available, in which case it's very difficult to make to code something that's a trade secret or to obtain enforceable patent rights because of that that software use agreement. So the care has to be taken to know what software is being used in your systems, and to know what if it's open source, for example, whether it's restrictive or permissive, in which case attribution may not be required, and you are more likely to be able to maintain trade secret or obtain enforceable patent rights. I wanted to just go through a little bit of a de-identified anecdote, and I take these anecdotes from different experiences that I have that are not particularly related to any particular client, and of course the names and the company the company products and the storylines are not directly related to any particular client, but based on my experiences, I want to just go over one particular anecdote that I've kind of created, and we're going to call this company the Wonder Puff Doll Company, and this company had a founder. We're going to call her Caitlin, and Caitlin had this idea of this particular doll, and again, this is not any real doll. This is just a pretend doll that I made up. But this doll, you could inflate, so your doll could be a little doll, a skinny doll, or a bigger doll, and Caitlin thought this would be a good idea, just so that a child could have the type of doll that matches the size that she might or he might prefer. Now, to produce this product, she enlisted the assistance of her neighbor Art, and Art made sketches of the characters, so that he made like a slew of different characters with different names and different features and different hairstyles and different clothing types, and then Caitlin made drawings of the apparel, incorporating Art's characters. So she did a lot of the dress design and the clothing design. And then she hired a local seamstress to actually make the doll patterns and the clothing patterns and whatnot. So I just wanted to use this example to try to explain the different types of intellectual property protection that could be associated with this particular venture by Caitlin. And so we want to ask, would you make, you could have a utility patent for this, which protects the function or utility of the invention. Could you have a design patent for this, for the ornamental and non-functional aspects? You might have a trademark registration for the company name, the logo, the slogan, and you could also have a copyright for this, for art's character sketches or Caitlin's clothing or apparel design. So there's a lot of different intellectual property protection came out of this this initial idea, and one of the most important things to figure out is, well, who's responsible for what? Who owns what? So you might ask, okay, well, who is the inventor for the utility patent? Who are the inventors for the design patent? Who's the copyright author? What is copyrightable? I would say that Caitlin, she would be the inventor of the utility patent because she conceived and intellectually dominated, as they say in the trade, the idea of the Wonder Puff doll, the actual functionality, the fact that you use particular systems to make it expand and contract. Art, the artist conceived and intellectually dominated the ornamental aspects of the doll, and he could potentially be the inventor on a design patent. Now, one might argue that Sue, who basically just, you know, did the actual design work on the patterns and putting it together, she's unlikely to be considered an inventor of anything because she took other people's ideas and just reduced them to practice. But irrespective of who's the inventor or who's the copyright owner, it's likely that Art would be the copyright owner of the character drawings, and Caitlin might be the copyright owner of the apparel drawings. But irrespective of that, it's important, since there's different levels of ownership and different parties potentially own different aspects of the this product, to have agreements in place. Now, in what happens often with new companies and startups is they don't have these agreements in place, and in this case, Caitlin forgot to have agreements. So coming to the table and asking someone to assign over these potential rights that that you have in this invention is very difficult after the fact, especially because you have to give someone some kind of consideration in order for an agreement to be valid in many cases. So the fact that she didn't initially ask for an agreement to assign these particular rights can be problematic when she goes back in the later after the fact to try to get these rights. So it's important to have your contractors sign over things that are likely to, sign over their copyrights, sign over their potential patent rights before they start working on anything. And it's not having those agreements in place from the get-go is also often a big sticking point. Also, when you have co-founders, it's important for you to know what your co-founders are bringing to the table as far as intellectual property is concerned. They may not have, they may have intellectual property they're bringing from other employers. in which case that can be problematic in the sense that these former employers may they may not this former employee may not have rights in that particular intellectual property. And in many cases, if you're bringing something from a former employer, you definitely don't have rights in that intellectual property. Just recently, there in the news, the past couple of years, actually, former Google engineer left with his name was Anthony Lewandowski. He left with a whole bunch of sensitive documents, which resulted in action by Google by way of one of their affiliated companies, Waymo. And it cost Uber, the company that brought on that particular employee, $245 million in damages for for bringing over that for hiring that employee. Also recently, court ordered Lewandowski individually, the former Google employee, to pay Google $179 million. So this was a very costly costly oversight for that employee, and for Uber for not having agreements in place and knowing what their new employee was bringing to the table. Employment agreements, it's a good idea to take a look at, ask new employees for employment agreements from their prior employers so that they can get an idea of what their liability might be. And it's also important to get your employees or co-founders or other people that are coming to your company to warrant that they're not bringing over any IP from another company. And lastly, it's important for if a co-founder is bringing some kind of intellectual property that he or she owned previously to your company, and it's actually his or hers, it's not intellectual property of his former employer, it's a good idea to get that employee or that founder to sign over that IP if it's related to your company, of course, in order to avoid any issues in the future that the employer or the co-founder saying, well, I'm leaving and I'm taking my IP with me because it was never yours in the first place. It's something that could really cause some problems for a company. So it is important to have an employee handbook and make sure that your employees, your co-founders, your potentially your contractors, your independent contractors, if that's how you're structuring your workforce, that they recognize that they are creating intellectual property and what they're supposed to do with that intellectual property, how they're supposed to handle that intellectual property. For example, like we spoke about before, there is a if you disclose your intellectual property, that may preclude you from being able to file a patent application later. So employees have to be informed of that so that they're not making disclosures, or if they do make disclosures, make sure that they're labeling those disclosures confidential so they're not considered they may be less likely to be considered public disclosures. Employees should be reminded of their contractual obligation to, let's say, provide future employers with a copy of your employment agreement. That way, future employers will be on notice that the things that employee is not allowed to be bringing his or her bringing to his or her new employer your company's intellectual property. So there's a lot of education that should be provided to employees and co-founders and independent contractors about intellectual property, so that you can be more certain that they're going to follow the rules, so to speak, regarding handling your company's intellectual property rights. Since we have a little bit more time, I just want to go into one last thing: mergers and acquisitions. I know for young companies that mergers and acquisitions might not be too near to the mind. However, it's something that a lot of new companies are working towards mergers, or they might have a couple smaller companies that are looking to merge to try to increase their visibility, or to try to have a better synergistic approach to different problems. And so even startups do mergers, so to speak. But when you are merging with another company, it's important to know, just like when you're hiring an employee, you're bringing a co-founder on, what they're bringing to the table. In a lot of cases, you think that a company is bringing certain intellectual property rights to a table, and they really don't own those intellectual property rights. A textbook case of that is in 1998, when Volkswagen spent a lot of money on RollsRoyce motor cars. They discovered after the fact that they didn't actually own rights to the Rolls-Royce name, which was an interesting conundrum, because that's probably what they were most interested in spending the $900 million on. So it came to be that they found out that that Rolls-Royce Motor Company didn't really own the Rolls-Royce name, which was actually owned by Rolls-Royce PLC, who subsequently licensed their Rolls-Royce name to BMW. So Volkswagen was stuck with some old factories and the Bentley name, which didn't have a lot of rights. Ultimately, they had to cut their losses and just gave their Rolls-Royce rights to BMW for a song, for not a heck of a lot of money. And they took a big loss on it, because they really didn't do the due diligence, or their attorneys didn't do the due diligence in figuring out what rights they were actually buying as far as intellectual property rights are concerned. So it's a good idea to figure out, when you're looking into a merger, or you're looking to a partnership, try to figure out exactly what rights that intellectual property rights that particular company or partner may have. So that's the substantive portion of the presentation. If there are any questions or comments from the audience, I'd be happy to address them at this point.
Thanks, Dimitri. I know sometimes it takes a minute for people to type up a question. So while we kind of give them a chance, if they do have any questions, could you tell us just a little bit about your background?
Yes, I'm a patent attorney. I've been doing patent law since 2002. Prior to being a patent attorney, I was employed as an engineer in the transportation industry, doing engineering design. I've also done some systems design for gas turbine test sites. So I've seen the world from the legal lens, as well as the engineering and the design and product development lens. I've been doing trademark work for past 13 or 14 years. So I have a broad knowledge of patents, trademarks. We do copyright work, and really a lot of I've seen a lot of different issues and in intellectual property, because I represent a very diverse client base, big companies, small companies. So yes.
Awesome. So I still don't see any questions from the audience, but this is recorded for all of our community members. So they'll be able to go back and look at this, and then we'll make sure you get added to that community as well for follow-up questions.
Great.
Come up. So perfect.
All right. Well, thanks for having me.
Actually, it looks like there's a question.
Okay.
So Ray says, what are the negatives or positives and negatives between using a law firm for trademarks versus online solutions like Trademarkia, or even just applying yourself? Good question.
Yeah, I mean, that is a very good question. Well, it's hard to give you a good answer. I will say that you know, a lot of my clients are very smart, very smart people, and they have a lot of good insights into the trademark process. But like any career or any particular vocation, there's a lot of technical aspects to that. So even if you've done a good job in researching the law and you have an idea for your particular situation what you might need to go forward, I will say that the technical aspects of, for example, prosecuting a patent application, it's extremely technical and almost impossible to get it right, or to get it done right well on your own, at least without having done a few, without having an attorney. It would be kind of like, you know, you could probably rebuild your own automatic transmission on your Oldsmobile. You know, you could probably do it, but it would take you a really long time to do it right. And even for trademarks, there's a lot of pitfalls in filing a trademark application. And as far as, let's say, like a company that I mean, I can't speak to any particular company, but I will say that there's a lot of nuance as far as trademark applications are concerned, even though they're what I consider to be deceptively simple, in the sense that you can file a trademark application, you can get a registered trademark, and then you can find out that there's a technical problem for your trademark. So even though you have a trademark registered, you don't necessarily have solid trademark rights. And I do get situations like that. You know, not every day, but a fair amount of time I do see situations like that where I'm called in to remediate a trademark issue.
Thank you. And then Miguel says, do we have any agreement with us for deals within the community? So we may discuss that. The short answer is no, but we can discuss that internally and see if there's something that we can do with Dimitri.
Okay.
All right. Any other questions before we wrap up here? All right, I haven't seen any others come in. Like I said, we'll make sure to add you to the community for follow-up, and then this is recorded, so we'll be sure to share that with all of our members as well. So,
all right, great.
Thank you so much, Dimitri.
Well, Kayla, thank you, and thank you to Shadow Ventures, and I'd be happy to do another one of these again.
Awesome. All right, everyone have a good day.
All right, bye-bye.